depending on where you are joining us from. For those of you who don't know me, I am Hannah Shea, World Law Group's Manager of Communications and Network Development. And today we are rounding out our ESG series with governance. This session is not only part of the 3-part ESG compliance series that we've been doing, but it's also part of WLG's week-long digital program, WLG at Large, that's taking place this week. You have been muted upon arrival, and we ask that you remain so throughout. This session is being recorded and will be available on the website by Friday. We do have a packed session, so I ask that you please drop your questions into the chat, and if we have time for them during the session, we'll respond. And if not, we will shoot you an email to answer those. I'm going to go ahead and hand this over to Joy Tan of Wong Partnership in Singapore, who chairs WLG's Compliance and Investigations Group. Joy.
Good morning, everyone. Thank you, Hannah. As Hannah's mentioned, my name is Joy Tan, and I co-lead the corporate governance practice at Wong Partnership LLP in Singapore. I co-lead the World Law Group's Compliance and Investigations Group. I don't lead it, as Hannah was saying, I co-lead it. Shout out to Ivan and Carla and my other co-leads on this call. I am very excited to be moderating today's WLG Compliance and Investigations Group webinar on the G in ESG. As Hannah says, this webinar is one of the closing events, I think it's the closing event of WLG at Large. This is WLG's annual members-only virtual conference that has been taking place over the last 3 days. World Law Group, I know that we've got some clients on the call, so just a quick intro about World Law Group. It's one of the oldest and largest global networks of independent business law firms across the world. It includes more than 21,000 legal professionals in 90 countries with 60 member firms. And Wong Partnership LLP is proud to be WLG's Singapore partner firm. As Hannah mentions, our Compliance and Investigations Group at WLG was set up last year. This year, we've had a focus on ESG. And the group has already had 2 very well-attended webinars on E and S with senior lawyers and eminent representatives from regulators in Europe and in Latin America presenting on those topics, together with our other WLG co-leads. Links to those webinars are available on the WLG website. So this is the session on G, on governance. I think as we know, these days, climate and social concerns are very much at the forefront of board and client attention. And rightly so, right? However, today we wanted to refocus with our emphasis on governance, without which really all the E and the S issues would be all talk, right? And would have no teeth. Governance issues, I feel, regulatory compliance, board accountability, all those things are critical for compliance and investigations lawyers as are on the call, as well as all our board and our issuer clients. And, I can think of no better party to address us on the topic of governance than Singapore's RegCo, and we're very privileged to have, you guys will see at the top of your screen, Michael Tang, who heads the listing policy and product admission from Singapore's RegCo to give us the keynote. Thereafter, we'll hear the London presentation on governance issues from Tom Abbott from the London Stock Exchange Group, PLC. Last but no means least, we'll have perspectives from the US and from Australia, presented by senior lawyers from Arnold & Porter and Winter Ellison, who are the World Law Group firms for the US and Australia, respectively. Without further ado, let me turn the webinar over to Michael, and let me give another quick moment to give you his deeper bio. As we said, Mike heads the listing policy and product admission at SGX RegCo, which, as you all may know, is the Singapore Exchange's frontline regulator. Michael oversees listing policies and rules development and has oversight of the listing admission of securities, including debt securities, structured products, and ETFs in Singapore. Michael is one of us. He graduated from the National University of Singapore with a Bachelor of Law degrees. He is a member of the NUS Business School's Center for Governance and Sustainability Advisory Board. He is a management committee member of the Global Compact Network Singapore and a member of the ESG committee of the Singapore Institute of Directors. Michael is the principal lead of RegCo's efforts to promote sustainability across stakeholder groups in Singapore and the region. Michael, we're very privileged to hear from you.
Thank you very much, Joy. Thanks for the invite. Thanks for the kind introduction, and very good day to everyone. Issues on environmental, social, and governance aspects, or ESG for short, have become mainstream considerations for businesses today. And I understand that today is the third in an ESG series where we will explore the governance, or G, in ESG. So with much of the attention paid to the E aspects, such as on climate change and pollution, and the S aspect, such as on workplace health and safety, it may appear to some that the G aspect is neglected. It is said that the term ESG was first coined in a landmark study, Who Cares Wins, published in 2004. This was a project initiated by the former Secretary General of the United Nations, Kofi Annan. The initiative brought together global financial institutions to develop guidelines that incorporate ESG considerations in the capital markets. This really marks the beginnings of corporate sustainability and ESG investing that we are familiar with today. The report acknowledged that companies need to take action and implement policies to address environmental and social challenges. In order to do so successfully, sound corporate governance and risk management systems are crucial prerequisites. In fact, governance is the first pillar in the global framework for climate reporting, the recommendations of the Task Force on Climate-Related Financial Disclosures. Information on governance processes are also required under leading sustainability reporting frameworks, such as the Global Reporting Initiative and the draft reporting standards of the newly established International Sustainability Standards Board. From a Singapore perspective, the Code of Corporate Governance states that sustainability, accountability, and transparency are tenets of good governance. In the SGX listing rules, we require boards to include a statement in their sustainability reports. The statement must explain the board's role in determining material ESG factors and overseeing the management and monitoring of these factors. In addition, the report must also describe management's role in resolving sustainability issues within the company. All this underscores the central role that governance plays in achieving all corporate goals, including those related to environmental and social aspects. The term ESG therefore highlights the fact that these areas are closely interlinked. Environmental issues and social issues must be analyzed alongside corporate governance issues. Governance is therefore the golden thread running through sustainability. If governance be the golden thread, then the board of directors must be the master weaver of the corporate loom. What are directors' duties in this respect? Under the corporate legislation of many jurisdictions, directors, in the exercise of their duties, must act in good faith in what they consider is in the best interests of the company. But what is the best interest of the company? It is perhaps useful to consider the object of this duty. There are two prevailing economic systems in the world today: shareholder capitalism and state capitalism. Shareholder capitalism places shareholders' interest at the center of economic endeavors as the driving force for the allocation of factors of production. It has as its mantra the maximization of shareholder value and Milton Friedman as its key component. State capitalism, on the other hand, considers the state as the dominant force which controls the distribution of resources. In recent times, a third form has gained prominence, that of stakeholder capitalism. This refers to a system which places attention on all private actors in society. It seeks to protect and guide their economic activities and to ensure that the overall direction of economic development is beneficial to society, and no single actor can free ride on the efforts of others. A key proponent is the Business Roundtable, a group comprising of 200 CEOs of the largest corporations in the world. In 2019, the Business Roundtable called on corporates to embrace the goal of managing companies for the benefits of all stakeholders, customers, employees, suppliers, communities, and shareholders. But stakeholder capitalism is not itself a new idea. Adolf Berle and Gardner Means, in their 1932 seminal text, The Modern Corporation and Private Property, advocated that public companies should have professional managers who would balance the needs of different stakeholders, taking into account public policy considerations. Further, managers need to watch how such needs and considerations change over time. Take climate change as an example. The understanding of its impact on businesses has evolved tremendously in the last 5 years. In addition to the physical risks of climate change, the business community is also asked to consider transition risks. For example, changing consumer preferences, emerging new technologies, and new regulatory policies on companies to take responsibility for their impacts on its environment. Notably, a legal opinion commissioned by the Commonwealth Climate and Law Institute said that directors must understand what climate change entails and how it would impact on their company's activities, strategies, and financial planning. Directors must also consider steps to prevent legal challenges to their company's business practices, especially given the risk of climate litigation. In New Zealand, for example, a court has recently raised the possibility of expanding the existing law of torts to include an inchoate duty on companies to minimize greenhouse gas emissions. The best interests of a company, then properly understood, naturally extend beyond just shareholders' interests. It also encompasses the interests of stakeholders in the communities in which the company operates. The duty of the director, therefore, involves the balance in serving all of a company's stakeholders and to reach a suitable compromise. Now, the law on directors' duties is focused on minimum standards, and that is the function of rules and regulation. But in emerging areas where minimum standards are expected to evolve, such as in corporate governance and sustainability, the use of flexibility may be preferred. A calibrated approach allows emerging best practices to be adopted by market leaders before consensus is formed on a market norm. Corporate governance rules, as we understand it, comprise statutory law, subsidiary legislation, listing rules, and codes of best practices. Mandatory requirements in rules and law apply to set baseline standards that all companies must comply with. The voluntary aspects in codes allows companies to choose the level of adoption depending on their individual circumstance, so long as its choice is explained. But the corpus of rules, with its focus on processes and systems, cannot tell a director how it should balance, or how he or she should balance the interests of the company's stakeholders. Worse, if boards treat governance and sustainability as a mindless tick-the-box compliance exercise. Good governance is necessary, but is insufficient in steering the company towards the right direction. Boards must transcend governance and move towards stewardship of the corporate purpose. As senior leaders, boards must inculcate the right culture and tone from the top by providing leadership around sustainability matters and considering it in the company's business and strategy. Engagement of the company's stakeholders is key in this respect. Lastly, I would like to touch on the role of lawyers in governance and sustainability. As legal advisors, you too play an essential role in upholding good corporate practices. In the course of your engagements with companies, It is important that you advise companies on the best practices that can be adopted, in addition to just what is the minimum baseline standards. Having this mindset and putting best practices into action would help to lift the overall standards of our markets. To conclude, it is important for companies to look at how they can implement a sustainable business strategy to future-proof their business and ensure their long-term viability. A key ingredient to do so would be to ensure that companies have effective leadership from its board and management. Ultimately, we want our companies to thrive, and governance is a key aspect of ESG that cannot be overlooked in the boardroom. On this note, thank you very much, and I wish everyone an insightful panel discussion later on.
Thank you so much for those valuable perspectives, Michael. I mean, I will say to all of our friends on this webinar that, you know, as a Singapore practitioner, I've always considered the SGX RegCo to be, you know, really forward-thinking regulator. You know, always trying to be on the front foot, you know, in terms of important topics and themes in, you know, the governance landscape. And at the same time, you know, the SGX does try to make regulation user-friendly for Singapore issuers. And I do feel that that approach, you know, absolutely applies to the critical topic of sustainability governance. I take that the clarion call that you're putting out to boards and to lawyers to move from sort of the shareholder capitalism to sort of stakeholder capitalism, right? And your call to move from governance to stewardship. Yeah, I mean, I really hope that we'll take these this clarion call to heart, and I do think that the panel actually is keen to discuss some of those themes. So you've given us quite a good segue into that aspect of things, right? Moving quickly to our other eminent speakers. We're very privileged, as we say, to have Tom Abbott with us from the London Stock Exchange. Tom has some slides, and I guess while he's setting up, let me do a deeper dive into his bio. So Tom is actually located in Singapore, and he is the head of Southeast Asia Business Development within the Primary Markets Division of the London Stock Exchange PLC. Tom joined the exchange in 2017, and his principal role there was to support the international development of the elite program of the stock exchange, which is an initiative for private companies looking to get ready for IPO. Tom has worked on a number of strategic projects, including the Shanghai London Stock Connect and other dual listing projects. Prior to his relocation in Singapore, Tom was instrumental in developing the exchange's voluntary carbon markets offering. Tom has a BA in Chinese and International Relations from the University of Leeds, and he's completing his MSc in International Management from SOAS. As I say, we're very privileged to have him, and we're excited to hear from him and the London perspective on governance.
Thank you, Joy, and thank you everybody for welcoming me here today with the WLG Group. Real privileges. I think I'm probably one of the only lawyers in the room, one of the only people not to be a lawyer in the room. So hopefully can provide a little bit different perspective in terms of how we work with companies to get them ready for listing and how they consider corporate governance in the UK, and how, with the approach the UK has taken over the past 30 years, or more, how it's really made us quite an international market, able to accept a number of different companies and corporate governance codes from around the world. But as the SGX Regu team touched upon, we're seeing challenges with how this can be applied with the E and the S, and how this has had to be adapted and updated a lot over the recent years. I first just wanted to start with sort of who the London Stock Exchange Group are. I think a lot of you should be relatively familiar. But one of the key things about this is obviously we have a number of different companies listed with operating companies on the equity side, as well as investment companies, and of course fixed income through bonds. But why this is important, and one of the key areas that we do get some confusion in within the corporate governance space within the London market is the different markets that we have at the London Stock Exchange. If we start on the left-hand side here of this slide, looking at AIM companies, this is for our small growth companies and has been a very successful market with over 800 companies there today. This is regulated by the London Stock Exchange itself. And then as we shift further right, we're typically growing in size of company and corporate governance code that can be adopted. We have main market companies. This is regulated by the FCA. And then our real premium listed companies for the real larger companies that have to stick to the UK corporate governance code or on a comply and explain basis is our premium listed companies. So a real sort of mixture of companies that come to our market and the different types of corporate governance codes that they can adopt to do this. How does this look in terms of those basic requirements? For premium, so switching direction this time, for premium listed companies, as I say, there's a real need to stick to the UK corporate governance code that was developed in the early 90s. For standard shares, so we see a lot of companies coming here from other jurisdictions or perhaps cash shells that can list in this space. And then another a real sort of highlight of the UK market, we have over 100 depository receipts listed on our market. So companies coming that are listed in other jurisdictions, listing their DRs over here that, again, instead of using the full UK corporate governance code, can use a disclosure guidance transparency rule related disclosure as to exactly what they're doing. With AIM, this again is an area that's changed quite a lot over recent years. Traditionally was very much no corporate governance code that needs to apply, just a statement of where this was. But recently, there has been a need to actually explain exactly which corporate governance code you are adopting. And there's been a real push to start using what we've termed the Quoted Companies Alliance Corporate Governance Code, something that's brought a lot more standardization to small and growing companies. In terms of the broader listing rules and requirements, again, with premium and standard companies, this would be looking at using a sponsor to come to the market. They're not always necessary in some cases, but with AIM companies, those smaller growth companies, we do have the need for nomads, nominated advisors, to take them through this process. And then in terms of other requirements around the significant transactions and so on, things that are quite standard across a lot of different markets. So the Corporate Governance Code itself, the UK Corporate Governance Code, as I mentioned, was first codified in 1992 following the Cadbury Committee's review. I mean, it was not designed as a rigid set of rules, but more a guiding set of principles, and really had comply or explain, a term that was actually developed by a Financial Times journalist at its heart, hoping to allow companies just to stick to the not the rigid rules, but go along with a set of provisions that could help them understand, that could help investors understand exactly where they were at. And the reason for the comply or explain was very much because it was recognized that a lot of different companies had very different sizes, complexity, historical ownership structures, and so on. So the impetus was really on making sure that companies were able to be able to put out these statements. Though again, as was mentioned, we have seen issues where perhaps people have used this as more of a tick box exercise and have just made sure that they have some kind of cleansing statement when it comes to certain provisions. But there has been a shift now from the FRC, the other regulator in this piece, the Financial Reporting Council, who control both the audit and accounting committees, but also the rules, but also the corporate governance code itself. And there has been a real push from them to look at ways of making sure that companies are actually putting out clear guidance as to why and exactly how they're not complying with any of these standards. And the reason this has become important, if we go on to the next slide, is that as investors have, as we've seen the growth in index investors and so on, we've seen a lot of companies that would like to make sure that they meet all of the different premium requirements, so want to be able to put out a statement that shows that they're meeting everything. if therefore that this just includes a very simple statement to somehow get to this point, it means that investors aren't really sure that they can necessarily trust all of this that has been coming through. So the FSC have been really big on pushing back on some of this. And the other thing that's happened here is a lot of these elements from what was quite a simple statement, a corporate governance code back in 1992, has now become a really, in the latest version in 2018, a really quite rigorous document with 18 principles across the 5 broader areas there, split now into 41 clear provisions that each of the premium listed companies must be meeting. On the other side of this, the smaller mid-cap companies, the Quoted Companies Alliance, this has been a push, again in 2018 was the most recent review of this, where there was a push to make sure that small and medium-sized companies were really clearly stating what they were doing, as it was becoming apparent that the E and the S piece of everything was going to be much more codified within UK company law. So there was a need to help and support smaller companies with clear guidance how they could meet some of their responsibilities without it being too burdensome for them and discouraging them from even coming to the market in the first place. Across all of these, I think, you know, the UK Corporate Code is in various forms, and the comply and explain model has been adopted now by over 50 jurisdictions worldwide. So it's quite a common area, but as we've already said, sorry, it's quite a common approach, but as we've already said, this is something now that as we focus more and more on the E and the S, there has to be slightly more prescriptive codified versions around this as well. For AIM companies, this little chart here, just to show that since the adoption of the QCA, we've shown that, you know, almost 90% of companies have decided to take on the QCA. But if you go down that list, I think there's a Singaporean company in there, and other jurisdictions where there still is that possibility on AIM just to state exactly which model and which corporate governance code that you are choosing to follow. How do we use this in our business discussions, and how do we talk to companies? As I say, you know, we're not a qualified lawyer here, and obviously the first thing that we do is we direct them to advisors such as a lot of people on this call to support them really in going through that process, as well as the banks and the nomads, to make sure that they have the various committees and non-executive directors and so on in place. So it really is about at the very early stage, even when companies are 18 months out to 2 years, even when they're approaching us about their listing prospects, we really like to make sure that they're thinking about the corporate governance piece from a really early stage, thinking about the different advisors that they'll need to be involving along the process, making sure that they actually have the teams and the structures to be able to support their different the corporate governance requirements that they'll need, and that they'll need to actually disclose on now that they're a publicly listed company. As I've said, I think since as we approach sort of the 30-year anniversary of the UK Corporate Governance Code in its codified form, there has been a realization and a recognition within the UK that there is a need for reforms, both to ensure the competitiveness of the UK markets, but also to make sure that the E and the S piece are really met. In terms of some of the recent reforms that we've seen dual class share structures now have been allowed for premium listed with certain qualifications around the lockup period and so on, and how long those dual class shares are allowed to be in place. We've also seen reforms to the SPAC view. We've also seen, since leaving the EU, we've seen the free float amount decreased to 10%, again enabling shareholders and existing shareholders of companies a little bit more control. We're also seeing a series of reviews that are ongoing and could see even more change in the future. The one thing I would highlight is, you know, we have been a very successful market with over 2,000 companies listed from all around the world. I think 40% of our issuers are international. And I think a large reason for that is some of the flexibility that we've been able to provide through the comply and explain regime. However, that's something that I think one of the key things that's come out of a number of the reviews is that as we've been through those 3 different markets and the different areas that were allowed, there has been some confusion upon exactly what makes a premium listing or a standard listing and so on. So some of the reviews and reforms themselves, I think, will be about simplifying that and making sure that all companies can meet these requirements. 2 large areas very similar to Singapore, back in 2021, we're the first of the G20 companies to adopt TCFD reporting across not just publicly listed companies, but also large private companies. And although it again is a comply or explain process, the explain here is very much about how you're planning to, in the future, meet your TCFD requirements. So it's not about finding excuses for not transitioning. It's about making sure that you actually have a plan to transition in the future. So as I say, we're the first market to adopt this, has been very successful in the first few years, also affecting private companies as well. The other side of this, another area that the UK has been leading in, has been more on the social side. So earlier this year, or towards the end of last year, sorry, we had new rules coming in from the FCA around board diversity, as well as reporting on the remuneration differences between senior management and employees, and as well as diversity and inclusion, obviously not relevant to companies all around the world, but a really important point for things that we're trying to do with UK listed companies, ensuring fairness across the UK. The difficult thing with both of these elements is that the original corporate governance code, as it was entwined, as was mentioned by my colleague earlier, very much focused on the shareholder returns and making sure that you had that responsibility to the shareholder. With the E and the S and these pieces that we are having to focus on more, or not just having to, but need to focus on more to make sure that we're continuing to live in a better world, have really been codified in a much stricter way to ensure that companies, both public and private, are able to adhere to them and make sure that they do adhere to them. How that then works on the comply or explain front, and how the corporate governance code itself has to evolve, is something that's a real hot topic within the UK, but also markets globally. And I also think, having heard my SGX colleague just speak, then an area where it's really ripe for collaboration globally, and something where we should really look to align, yet respecting individual jurisdictions' rules where we can. On that note, I will close there and look forward and hopefully set up a really great panel discussion on that evolving picture.
Thank you very much, Tom. What a broad swathe and international swathe as well of listed issuers on the Singapore, on the London Stock Exchange. And I guess we're interested also in the focus that you bring to Singapore and this part of the world, right? I do believe that increasing the interest, and it does increase the pie for all of us practitioners as well as regulators and not just Singapore, but all the UK, but really this part of the world as well, right? And I think as you mentioned, we do have strong professionals across the various jurisdictions who would be happy to assist listed issuers with the listing process and the governance compliance aspects as well. So with our presentations concluded, today's webinar will move now to the roundtable panel and share perspectives from the US as well as Australia, and I'll wrap up with Singapore. To this end, I want to welcome 2 senior practitioners from our partner WLG firms in the US and Australia, Greg Harrison from Arnold & Porter and Rebecca Bedford from Minter Ellison. Greg, as you'll be able to see from his background, is based in Arnold & Porter's Washington office, where he co-heads the firm's sovereign finance practice. He received his law degree from the University of Chicago Law School and did undergrad studies at George Washington University. He's a transactional lawyer, and he regularly advises clients in corporate finance transactions, including the sale of securities in the US syndicated and bilateral lending transactions, as well as project finance. He also advises on compliance issues under the US securities laws, including Dodd-Frank, Sarbanes-Oxley, and FCPA. Rebecca, like me, is a disputes lawyer and partner at Minter Ellison. She advises public and private sector clients on governance and risk issues, including regulator risk and directors' duties, cross-border disputes, large-scale commercial disputes, including joint venture disputes, as well as investigations, royal commissions, and commission inquiries. And she's got an engagement for the ongoing Disability Royal Commission in Australia. Greg, Rebecca, welcome. In this panel, we are largely seeking to discuss what US and Australian and Singaporean directors are most concerned with from the perspective of corporate governance. You know, what kind of crosswinds are they facing? What can external counsel do to help them in that regard? And just a nuance there, I should say that though our speakers from SGX Redco and the London Stock Exchange have approached the governance topic from the perspective of listed issuers, our panel's remarks will also extend to non-listed boards and directors owe the same duties under common law as they do from the listing perspective, as well as the non-listed issuer perspective. So we did want to address the remarks in that vein. So let me first invite Greg to give the Washington and the US perspective in terms of what governance issues are your boards most concerned about. And we've also heard a bit about listing requirements in the UK, and that I guess that was a bit of a challenge from Tom in London. Is there anything from the US listing requirements that you'd like to mention in this panel?
Well, thank you very much, Joy. I think this is going to be a fascinating discussion. I really enjoyed hearing Michael's perspective as a regulator, as well as Tom's from somebody at an active stock exchange. And I'm going to discuss a little bit about the stock exchanges and a lot about regulations. It's a shame that my background has the Washington Monument and the Jefferson Memorial. It probably should have the SEC and the US Congress instead for this discussion, but that's the background that we have. When we think about the G in ESG, that's again governance, and I'll be speaking about it from the point of view of the United States. When we think about G, it's a rethink, and I think Michael touched on this very, very well, a rethink in terms of the purpose of the corporation, the role of the board of directors, the composition of the board of directors, and Tom got into that a bit as well with respect to London Stock Exchange, compensation and oversight of top executives, and more broadly, human capital management. And when we think about the United States, and we think about what boards are facing, both large, mid-sized, and even smaller companies, they're facing challenges from a number of different areas. In the US, you think both of federal government and state government. Federal government, especially for listed companies and companies that are reporting with the SEC, you think about a very active Securities and Exchange Commission, and certainly very active in the past couple of years. But you also have to think, because of our strange federal system, about state governments. And I think as many people on this call will know, US companies are really not US companies. They're companies that are incorporated in individual states as opposed to incorporated in the United States. So you'll be faced with, typically for a larger corporation, Delaware, but that could be California, New York, Illinois, or 50 or so different jurisdictions. So you've got federal and state governments. You've also got investors, and especially activist investors, activist shareholders who have various agendas that members of the boards of directors have to deal with and have to face. Increasingly large institutional investors who are taking a role that traditionally has been left to politics and policy, but institutional investors are increasingly getting into directly making demands of companies on ESG aspects. You've got, I think Michael mentioned this in terms of stakeholder versus shareholder, you've got the so-called stakeholders, which are not management, they're not shareholders, but they are groups or individuals who have an interest in what the corporations are doing. And then, of course, you've got the proxy advisory firms, which orient institutional investors on how to vote. One interesting aspect, I think, of US governance that certainly larger US companies and listed companies faced is the so-called federalization of corporate governance. As I mentioned, corporate governance, companies are typically incorporated in states. So you've got state corporate law, again, Delaware. But then you also have this interesting aspect of the United States where you've got the federal securities laws that come into play. So you have to worry about what Delaware, California, New York, or what have you, are doing where you are incorporated, but also what the federal government is doing. The federal government has been taking an increasingly larger role in corporate governance, certainly since the 1930s when the Exchange Act and the Securities Act were adopted, but also more recently you see it in Sarbanes-Oxley in 2002, in Dodd-Frank in 2010, and so on. And the way that in the US, the odd system is that because the federal government really cannot impact directly state corporate law, because that is meant for the governments of the various states, they typically implement it through the stock exchanges. So if you're a listed company listed on, for example, the New York Stock Exchange or the NASDAQ, you are indirectly regulated by the federal securities laws because you must also comply with the rules of the stock exchanges. And that creates an increasing tension between state corporate law and what the federal securities laws are requiring. The other pressure, and I think Michael mentioned this very, very directly, is this move from traditional shareholder-centric model in the United States to a stakeholder-centric model. And so increasingly companies and boards of directors are being required to consider the role and the views of other stakeholders other than shareholders in corporate decisions on environmental issues, social issues, and increasingly governance issues. That is a bit of a conflict if you're a director with the traditional view of, mention Milton Friedman's view of maximizing shareholder value. So how do you combine maximizing shareholder value with also trying to keep increasing stakeholder-centric pressure on you? And one of the aspects of that is the business judgment rule. So you may want to move to a stakeholder-centric model, but you're still subject to the business judgment rule in your home jurisdiction. So for example, in Delaware, the business judgment rule protects directors from their decision-making and means courts won't interfere with their decision-making if they are following their fiduciary obligations, which are acting in the best interests under Delaware of stockholders, not stakeholders. So there's an increased tension that you see in US corporates between stakeholder and shareholder capitalism. And you see that without getting into specific names, but in many headlines in the United States, you see, certainly during the pandemic, of companies getting into the news because they are being forced into, by different players, political questions that they've traditionally tried to avoid. So again, US companies face the governance issues from both federal, state, and increasingly from their shareholders and now the stakeholders. Specific initiatives, so that was very generic, but what you see in terms of specific initiatives from the federal government often come from either direct law, such as Dodd-Frank, Sarbanes-Oxley in 2002, but also SEC's initiatives. We touched briefly on, and I think we discussed it in other webinars, on the SEC's pending ESG reporting requirements, which we are expecting to be adopted probably early next year. Nobody knows yet. And one major question of that is whether it will be upheld in the US courts. But I don't really want to discuss the SEC's ESG reporting initiatives because, again, I think we've discussed that in other webinars. But there are others in terms of the G in ESG. In 2011, a say on pay requirement that came out of Dodd-Frank, where shareholders every couple of years are allowed to approve or not executive compensation. A pay ratio disclosure, where companies that are listed companies are required since 2015 to disclose the ratio of CEO pay to the median employee pay. And then as of this year, more disclosure, pay versus performance, as of 2022, showing the relationship between executive compensation and financial performance of the company. So again, you're seeing this federal encroachment on areas that have historically been reserved for state corporate law. The SEC's ESG proposal, again, part of that. And then also separate from Dodd-Frank, now there's a requirement to have a universal proxy, which is an initiative from the SEC, which will allow, in case of proxy fights and disputed board seats, activists and other shareholders to have a greater ability to nominate or not vote for the role, the proxies and the planks and the directors nominated by current management. So again, how does the US stock exchanges get into this? And I think it was interesting with Tom's presentation about the London Stock Exchange. What are the G initiatives of NASDAQ and the New York Stock Exchange? Well, like London, NASDAQ and the New York Stock Exchange have long had certain corporate governance standards. So for example, requiring a certain number of independent board members, requiring board committees such as nominating and compensation committees. But more recently, you're seeing a role from both NASDAQ and the New York Stock Exchange on more recent governance issues. So for example, to promote greater diversity among directors, but the two stock exchanges have taken different approaches. NASDAQ has taken the approach, as Tom called it, the comply or explain. We more likely call it name or shame approach, where they're required to have, under NASDAQ rules, either have two diverse directors or explain why not. So again, whether it's called comply or explain in Tom's words, or name or shame as it's typically called in the United States, that's the following. The New York Stock Exchange has taken an even lighter approach where they have set up a committee to help identify qualified diverse candidates so that companies seeking more diverse board directors can go to the exchange and seek candidates that way. So the NASDAQ's approach is more similar, I think, to what Tom was explaining for the London Stock Exchange, whereas the New York Stock Exchange's role is even more passive. Even that NASDAQ role, the name or shame, the comply or explain, has been challenged in the courts on equal protection grounds, whether it violates the anti-discrimination laws in different states, and whether it even exceeds the authority of the SEC, which approved these roles. And then finally, on the state side, you're also seeing different states try and implement on the governance side different rules. Most famously, California, but other states as well. But California has had two laws on the books since 2018 and 2020 to promote, and actually in that case, require companies which are listed companies as well as headquartered, not incorporated, headquartered in California, to have at least two diverse directors from underrepresented groups. That has been challenged again in the courts and has been held to be unconstitutional under the Constitution of California, but it does show that states also are very active in promoting better G governance in the ESG world. So again, in the US side, it's been a very busy time for directors of US companies, and we will see. It's an ongoing conversation in the United States.
Thanks so much, Greg. I would say that Singapore similarly has, the business judgment rule as part of our legal system, but what we don't have is the same culture of litigation as in the US, and I suppose many jurisdictions would be able to say that, and certainly Australia as well. So if I could pass the time to Rebecca to give us the Australian perspective. Rebecca, we would ask you what's keeping Australian listed boards as well as non-listed boards up at night, and I understand that you'd like to approach this also from a consideration of the areas of risk, right? And let's get, I guess, a bit more granular here. It's good to talk about principles, sort of stockholders versus stakeholders, but granularly, what kinds of areas of risk are you seeing?
Thanks, Joy. I may just say that in terms of the structure and framework, Australia has features of each of the jurisdictions we've spoken about. Governance is enshrined in legislation and monitored by federal and state regulators. In terms of how listed companies are managed in Australia, they're managed by the Australian Securities Exchange, or ASX, and that is regulated by federal regulators, including ASIC and APRA. There are various listing rules for public companies, continuous disclosure obligations, and a number of our speakers mentioned those. In terms of governance, the ASX does have a council, the ASX Corporate Governance Council, that issues principles and recommendations. And what those do, they inform and guide entities of their ESG obligations, amongst other things. They are supplementary to the ASX listing rules, but like Greg and others have mentioned, public companies must benchmark their corporate governance against, or practices against those, and they must disclose in their annual reports if they don't conform and why they don't conform. So those 8 principles include laying the foundation for management and oversight, structure to the board so that the board adds value, instilling a culture to act lawfully, safeguarding the integrity of corporate reports, respecting security holders. The one that I'm really going to talk about is managing, recognising and managing risk, and remunerating fairly and responsibly. So if we look at those principles and view those through the prism of governance, I think in Australia it's very difficult to divorce the G from the E and the S. And that's particularly so given that Australian regulators have really taken a key role in ESG policies, environmental and social risk, and incorporating impactful diversity policies. And in terms of governance, I think we need to boards really need to bear in mind that ESG is a financial risk to boards. That is the first message. And regulators are certainly holding boards more accountable. But in terms of themes, what we're seeing, like Greg mentioned, is shareholder activism. And listed companies face significant shareholder activism. Shareholders are agitating for governance change to pursue those social and environmental change. Recently, we saw there was the proposed demerger of AGL Energy, and there were the efforts of shareholders, including Mike Cannon-Brookes. The demerger was ultimately withdrawn, and the CEO and chief executive resigned when it was clear that that proposal wouldn't secure the 75% of vote required. Shareholders are becoming more strategic in terms of pre-litigation and litigation steps. It's clear, particularly so in the E and the S space. But as I mentioned, it's difficult to divorce those from the G. We've seen actions by trustees of a pension fund, allegations that the pension fund or the trustees failed to provide shareholders or beneficiaries with plans for managing climate change. We've seen actions by shareholders exercising their right under the Corporations Act. They get access to the books and records of a company for certain information. They then frame their claims following receipt of documents, and certainly we've seen that in the greenwashing space. As Greg mentioned, Australia's the same in terms of REM proposals for directors and actions to remove key personnel. In terms of risk, it remains a key governance issue in Australia. Cyber risk is the -- risk, I think, here facing boards, whether you're listed or you're a private entity. And what we've seen recently is we've seen 2 significant cyber threats. And as a result of that, regulator investigations and shareholder investigations. And I'm just going to mention one recent case. An Australian financial services licensee was found to have breached its licensee obligations, and ASIC took action against it for failing to adequately manage its cyber risk. And I think we're going to see more action around that area. Managing class actions is particularly significant here, and listed companies, they're operating under that omnipresent spectre of class actions. It is everywhere, and they need to manage those risks. And the question I think facing listed companies is, do we fight them? Do we agitate them in court, or do we settle them? And we're particularly seeing that in the mining space, where again, people are getting more inventive about how they bring those claims. Another key risk area is managing geopolitical tensions and sanction-related issues. Australia is no different to other countries, but where they're operating in international markets, they need to manage those in terms of supply chain risks. And what we're seeing also is where there's an unskilled labour, there's elevated risk of modern slavery. That is a key risk area in Australia. What it means for listed companies who need to disclose compliance with modern slavery laws and really private entities is that you've got to look beyond your immediate supply chain. You've got to look to other supply chains. The other speakers have spoken about directors' duties. The impact of all of that, all of those risks on directors is significant because they're on the hook if they don't have sufficient oversight. And we've seen a Financial Services Royal Commission that's highlighted the importance of directors holding management to account, and there's significant penalties for directors. The final governance risk that I want to mention, and Greg has mentioned it as well, is governance. Governance, it's not just in terms of gender diversity, it is cultural diversity. And I think it's inclusion of people with disabilities on boards. And there's the current Royal Commission in Australia, and what that is doing is really shining a spotlight on the extent to which people with disability are included on boards and at the executive level. To what extent are their voices heard? Board composition, Greg mentioned that it's particularly important in terms of ensuring appropriate renewal, in terms of gender diversity, other forms of diversity, and appropriate skill sets. So that's it from the Australian perspective, and certainly the governance risks, it's fluid, as it is in all jurisdictions. It continues to change, but I think that we'll see the issues that we spoke about today will be significant in the future, and boards and directors need to be aware of those.
Yeah, absolutely, and thanks for that perspective on Australia, Rebecca. I was going to wrap up this fascinating discussion on governance around the world from the Singapore perspective. In the same way, you know, as we've heard from the other speakers, governance demands in Singaporean boardrooms are changing and increasing. SGX RegCo, like other regulators, does expect greater board oversight over a number of now not purely Milton Friedman type concerns, right? That include environment, transparent and fair compensation, and a diverse and independent board composition. So just very briefly, here in Singapore, we do similarly have a comply or explain regime, and it's the 20th year anniversary of our code of governance, and that works side by side with the hard-coded requirements. In Singapore, we've made climate reporting mandatory for certain issuers in certain sectors from 2023 and 2024. For the other sectors, it's only comply or explain. And our regulators have also hard-coded a requirement from the start of this year for issuers to have a board diversity policy, right? Which was, previously it was comply or explain. Now it's hard-coded, and issuers must disclose in its annual report targets for achieving the stipulated diversity. That includes gender, diverse skill sets, as well as age. We haven't quite sort of embraced, disability in our review of diversity, but certainly if that seems to be the way that global standards are going, I'm certain we will also see that on our horizon. In addition, we have a live consult from the SGX to require a hard tenure limit of 9 years for independent board directors. As with many jurisdictions, we do have a requirement for listed issuers to have 1/3 of their board comprised of independent directors. So this move towards a harder tenure limit for our independent directors that are long-serving is an important change in the Singapore landscape and will improve the state of governance and accountability, I think, across our listed issuers. Secondly, the consult also is about hard coding the requirement for disclosure of the exact amount and breakdown of compensation for board directors and CEOs on a named basis in the annual report. And we currently don't have this, it's comply or explain, but if we do hard code this move, it's gonna bring disclosure requirements in Singapore on compensation more in line with global standards. Very quickly, in terms of boardroom risk, like in Australia, cyber is a key risk for Singapore boards. We've had several major hacks. And since then, Singapore has made data breach reporting mandatory for serious breaches. I mentioned that litigation risk is generally regarded as low here in Singapore because of our environment, our cultural environment, but also in terms of the various legal barriers to sort of plaintiff-led class actions that you see in the US and in Singapore. We don't have that mechanism. We have an opt-in representative action model, which is, I think, applicable in the UK. That said, thanks to our robust regulation and regulators, regulatory risk remains high for Singapore, right? And we've seen very recently action taken by our regulators against the executives and independent directors of one of our prominent listed companies that has had a corporate collapse recently. Climate risk, I think, is an increasing area of risk for boards in Singapore, largely because Singapore boards haven't really gotten to grips with it, right? Despite the efforts of Michael and the SGX RegCo team to help our issuers level up in that regard. Greg mentioned the risk, the increasing risk arising from the increased shareholder activism. Singapore, I think, is no exception to that. I did mention Singapore's low litigation risk environment, but there has recently been an environmental related suit involving the Papua New Guinea Petty mine. I think that's something Australian lawyers would be familiar with. That was recently brought before our courts. One of the defendants is a Singapore incorporated entity, and it was struck out by our Court of Appeal, but it may well be a sign of things to come. So, if I were to crystal ball gaze in terms of what sort of governance trends and risks would be important for the future, I'd say for Singapore, probably the most important risk there and trend would be sort of climate and the concerns around sustainability reporting. Just very quickly, Greg and Rebecca, what's the one area in each of your jurisdictions? Greg, for the US, for the future, what's the future of board risk? What does that look like for you?
Those are all risks, and I think that's been a fantastic between you, Joy, and you, Rebecca, really raised risks that are also applicable in the United States. I think what people are waiting for is to see the SEC's ESG requirements and to see what happens there. So I think one of the things that people are looking at is, so for example, as part of the ESG requirements, it's suggested that each board should have a member of the board who is an ESG, an environmental, especially specialist, and or name or shame, if you will, or again, going back to Tom's comply or explain. So I think that what directors are looking at right now, in addition to everything else, is for the large public companies, what's going to be the SEC's ESG final proposal.
That sounds interesting and also alarming, right? Which is not a bad thing. Rebecca, very quickly, the future of risk and governance in Australia.
The number one risk is climate, and we've seen in Australia, including recently, the risk associated with mining application permits, for instance, and challenges to those permit applications or permits once they're granted on environmental grounds, and shareholders coming together to make those challenges. So it is beyond a doubt climate change, I think, in Australia. So it's environmental, followed very closely by cyber risk.
Great, thanks for that, Rebecca. So everyone, we've come to the end of our webinar. I'm afraid that there hasn't been time for a substantive Q&A, but we have collected the questions that are in the private chat, and please feel free to reach out to any of Greg, Rebecca, and myself. Our emails are on the WLG website. If you'd like a sidebar on any of the topics that we've raised and like to discuss any of these things further. And you know, if there's anything that Michael or Tom can respond to constructively and openly, I'm certain that they do that as well. So please feel free to drop you know, any queries that you might have for them to us similarly. It does remain for me to thank Michael and the SGX Redco team, to thank Tom from the London Stock Exchange and my colleagues, Greg from Arnold & Porter in the US and Rebecca from Minton's in Australia. Thank you very much for your questions and your participation in today's webinar. And I would wish you all good morning, good afternoon, and good evening from wherever you are in the world. Thank you all very much for joining us today.